The ICAC experience in New South Wales visited needless humiliation on many high-profile figures. Barry O'Farrell, an undeclared gift of a $3,000 bottle of wine. Premier Nick Greiner, after offering the Liberal-turned-independent MP Terry Metherell an executive position in the Environmental Protection Authority. ICAC's finding against Mr Greiner was overturned by the courts long after Mr Greiner had to resign as Premier. Mr O'Farrell was never charged with anything. It's instructive to note that 3 South Australian King's Councils, 2 men and 1 woman, wrote on Monday that without adequate safeguards, corruption commissions had the capacity to operate as a star chamber and to have consequences that were significant and irreparable. Their words, quote, "In our experience, the process and stigma of being a person who has appeared before a corruption commission, should that appearance be made public, becomes a very severe punishment," unquote. They further wrote, "Some commissions outside South Australia hold public hearings that result in public humiliation and the destruction of reputations. The processes invoked by corruption commissions bear no relationship to fair processes a court must apply," unquote. Now, of course, the Greens and the Teals are up in arms over what they claim is the Dreyfus plan to restrict public hearings. But in fact, this National Anti-Corruption Commission will find it easier to hold public hearings than is the case with the New South Wales Independent Commission Against Corruption. ICAC can't hold a public hearing unless the Chief Commissioner and at least 1 or 2 other commissioners agree. There is no such restriction in the national scheme. And I repeat, the National Commission can start its own investigation without a referral and without any need for a criminal offence. And while the bill says that the public hearings may be held in exceptional circumstances, that's no restriction. And the term, as I said, exceptional circumstances, is undefined. And unlike New South Wales, where changes have been made such that an ICAC commissioner is now required by law to consider the risk of reputational damage to the person being subjected to a public hearing, there is no such compulsion for this National Commission. It may have regard to reputational harm, but it's not compelled to. These corruption instruments wield immense power. Here is that power spelt out. The proposal for a National Anti-Corruption Commission gives the power of the Commission to start its own investigation without a referral. It can investigate retrospectively. It can investigate without the need for evidence of a criminal offence. There are no limitations on public hearings. This legislation needs significant and urgent amendment. Peter Dutton, here's your chance. Get to work.